The Gwart Show is sponsored by Ellipsis Labs. Ellipsis Labs is building a world where mainstream finance happens on-chain. Their first product, Phoenix, is a fully on-chain limit order book DEX on Solana doing hundreds of millions of dollars in volume. I know this team personally. It's one of the strongest in the space. If you're interested in working with a team that's here to stay, Ellipsis Labs is hiring engineers passionate about DeFi to join their team. You can find Ellipsis Labs on Twitter at ellipsis_labs or head to ellipsislabs.xyz to learn more and apply. Hello, today we have Gabe Shapiro, very well-known crypto lawyer and somebody who I have a lot of different questions for. Probably most listeners know him, but Gabe, if you want to introduce yourself, maybe tell us what you're working on. I know you're working on a lot of stuff, but maybe like give us the broad strokes of what you're working on.
My name's Gabriel Shapiro. I'm a California licensed attorney, and I'm the co-founder of a project called MetaLeX, which is specializing in cybernetic law solutions, primarily at the moment for DAOs. And I've been in crypto, been an attorney for 14 years, been in crypto for 7 years. Before crypto, I was very mainstream corporate buy-side mergers and acquisitions attorney. And now I do this stuff.
Nice. Yeah. So like as of late, you've been working on MetaLeX, which is your company, and then I guess your main project there is Borgs, which is sort of it's like a framework for DAOs and cybernetic organizations. So yeah, can you just like give us give us an idea of what was maybe the motivation for this and where you're trying to go?
Sure. So I was advising a lot of crypto projects for years, primarily DeFi projects. A lot of them had DAOs of one sort or another. And in giving them legal advice, I sort of observed a few things. Number one is that the term DAO had become close to meaningless. So many different things are called DAOs, ranging from basically traditional venture capital funds that happen to use smart contracts for some of their operations to, very decentralized protocol DAOs, like MakerDAO and Curve. And so just the term, no one knew anymore what they meant by DAOs. And so I went back to the old literature, the original articles, Stan Larimer, Dan Larimer, Vitalik, and tried to really hone in, okay, what is a DAO? And then what's all this other stuff, right? What is a venture capital fund that happens to use a smart contract and to have in its LP docs that it has to use that smart contract? Do we really want to call that a DAO? And I decided, no, you don't want to call that a DAO. It's not really decentralized. It's not really autonomous. So I came up with this other concept of a cybernetic organization, or Borg, just to differentiate. So there's kind of a nomenclature issue straight off the bat. What are we really talking about here? And then on the legal side, what I observed repeatedly is that I could come up with really cool ideas for how to give clients the right type of narrative and substance for their project, that it doesn't fit into a heavily regulated category, or that it's compliant, with whatever regulations might apply. But repeatedly, I ran into the issue that these would require certain technical implementations, right? And that they didn't have those technical implementations. And even though, they have smart enough people that they could build them, that's not their project, right? So they don't want to put their project on hold for 6 months to build this governance/legal solution, when they're supposed to be building their actual, DeFi protocol or whatever, right? So putting those two things together, I kind of thought there's a need in the market here for someone to build these types of solutions and clarify these governance arrangements. And I just decided, let's do it.
What did you find to be the biggest problems with DAOs? Like maybe just some of the main motivations in terms of where you saw the DAO landscape and then where you wanted it to go now. Maybe my thinking here is there's been DAO governance organizations like Aragon, right? Like, but this focuses more on, I think, like governance specifically. And I think you're trying to intertwine now like the legal aspect, which is probably equally, if not more important. So what did you see were like the big, like maybe standout problems, and like how are you trying to address those?
Yeah, well, I would say the biggest problem is that a lot of DAOs have just become something very similar to on-chain corporations, right? Yet, and they kind of suffer from what I call the worst of both worlds syndrome, in that a lot of times they have all the same principal agent problems as a traditional business, right? Committees of people, multi-sigs, core developers, whatever it is, people who are getting money from the DAO and who the DAO is depending on, in some sense, the DAO being token holders, but who, unlike in a normal, so just like in a normal corporation where there are shareholders and there's management and employees, same dynamics, right? Principal agent dynamics. But unlike in a corporation, none of the accountability mechanisms that you would find there and minority rights protection mechanisms apply. And in fact, because crypto people tend to be so legally naive and don't know the baseline of how just normal corporate law works, in a certain sense, they don't even know what they're missing many times, right? Like they don't even see the issue of, oh, the majority is deciding this, but the majority has this conflict of interest and it's screwing over the minority, and there's literally nothing they can do about it, right? We're so used to thinking about forks as a minority remedy, but like you can't fork a DAO because it has assets. So I think and then on the regular, so there's just kind of like the plain old fairness, good performance, accountability, good governance type of stuff. And then there's that are downsides to running a DAO like it's a corporation without the normal rules. And then there's the regulatory side of it, right? Which is that the law, and this is one, I'm as anti-authoritarian as probably a lot of people in crypto, but the one kind of aspect of law that I think can be good is that where there is a situation where there's a weaker group depending on a more powerful or more informed group, that the law pretty typically tends to read in some combination of regulation and fiduciary duties and things like that into that situation to protect the less powerful people. And I actually think it's a really good feature of law, right? But it will mean that if you're running your DAO with all these trust elements and these principal agent elements, of course, then the same types of laws are going to end up applying to that, right? But you're not addressing them, you're not following them, right? So there's other things like tax and stuff like that. I won't get into all that, but it's just a really big issue to try to run these DAOs as on-chain corporations. And I think it's also a little bit contrary to the original vision of DAOs. Although like it came from the concept of Stan Larimer calling Bitcoin a decentralized autonomous corporation. It wasn't the best terminology, but if you actually read his articles about it, he didn't really mean that it's a corporation, right? He was drawing an analogy, and the analogy is basically to like a very limited corporation that only pays that only has code as rules. All of its rules are in code, and it only pays workers in its own shares, which in the case of Bitcoin is BTC. Right. But we've gotten very, very far away from this because we're paying people in DAI, in other things, even in like, token options and things like that. And they're working off chain, and their rules are not only code rules. They're also social rules and promises and expectations. And that is the realm of law. Right. So the purpose of Borgs is to say, look, let's get back to this simpler version of DAOs, which I think is defensible to potentially not be regulated. And personally, I would stop calling them DAOs, because if you have the word organization in it, it would be treated legally as an organization. I would call them like, in a sense, they provide a security function with respect to funds, right? And they also provide sort of a sentiment measuring function among, interested stakeholders, users and so forth, right? And then let's put the businessy parts of it into these legal entities that are designed to do that, right? But let's also reduce trust with some smart contract-based controls that flow back to the DAO, right? So I think that's a vision that could be very sustainable and that a lot of people are moving to in different ways. I just felt like there needs to be a meme for it, so therefore I started calling them Borgs.
Yeah. The point you made about maybe potentially some of these organizations could not be I don't know, regulated or regulated. It's certainly not in the same way as like a traditional corporation. What about Borgs in your mind? So like, I guess you kind of delineated there between like the business activity side versus the, I guess like more trust minimized side. With regards to this, like more trust minimized side, where do you see this as being like an unlock insofar as, okay, this probably doesn't need the regulatory oversight that, say, like a traditional, shareholder corporation may need?
Right. A couple of things. Number one is just like making very, very clear what the rules and expectations are, right? So, if you have people and you call that, like Aave has, for example, they call it a guardian multisig, right? And as far as I know, it's unincorporated and there's not kind of a charter that governs the basis on which those people are supposed to make decisions. So like, look, an ordinary person hearing that there's a thing called the guardian multisig, I mean, they may think that these are people who are just looking out for them generally, looking out for users of the platform generally, and, or like a board of directors or something, right? But in reality, I think their role is more limited. It's more of a security role. And so now imagine if you wrap it in an entity, the entity's rules literally explain we have only a security function. We will only act in such and such circumstances. You define what an exploit is or whatever, right? And you define the range of permissible ways that these people can react to that, and then you publish those rules. Well, now it's very clear to everyone. And I think, and you disclaim in those documents, you say, look, we're not trying to have fiduciary duties to token holders. We actually don't care how much the Aave token is worth. Our only purpose is to secure deposits into the Aave protocol, things like that. You just start making it very clear, and it becomes hard for a plaintiff's lawyer or a regulator to come along and say, these guys are in charge of everything. These guys are the guardians, after all, right? They owe fiduciary duties to everyone, or whatever it might be. So just the clarity helps. Number two, in terms of, because these people do have some power, not unlimited general board of directors power, but some power, they could like pause the protocol if there's an attack or whatever. You do also want to have some form of accountability. Now, the bad form of accountability, I think, would be just to recreate the traditional shareholder board of directors relationship, like basically give DAO token holders contract rights to like remove and appoint these people at will, and recreate the fiduciary duties, whatever it is, right? But I think the cool thing is with the technologies that we have, and also some legal structures that are relatively novel, like memberless, beneficiary-less foundations that work a little like smart contracts on the legal side, you actually can create a situation where you have an entity that just kind of follows its own rules. Those rules are clear and known to everyone. People can depend on it for that reason rather than being owed broad duties or this person being a licensed type of intermediary by a regulator. And if something goes badly wrong, there are some mechanisms where the dependent people can self-help. So those would be, for example, like let's just say a typical case would be an entity that has gotten some funds from the DAO, and that's expected to be a 3-year budget for whatever it's doing. If nothing else happens, right? If it's just like the typical black box foundation, well, they don't owe any duties to token holders. Their own rules are relatively vague and just give them discretion about how to spend their own fund. I mean, they could spend that money in a month if they want. So if a Borg or multisig has gotten a bunch of funds from the DAO, and let's just say part of the DAO proposal was these funds are going to last us 3 years. Well, the way things were going before Borgs, on the legal side, the entity that it went into, if there even was an entity, it would just be a very boilerplate set of documents like any business or foundation that just says, use your funds reasonably or something like that, or use them for lawful purposes, right? What we can do with Borgs is we could be much more specific. In the legal rules, we could say, the money that you got on such and such date needs to last you 3 years. But also on-chain, we can put that in a multisig that is programmatically rate limited, not to be able to spend the money faster than 3 years, right? Now, there is some downside to that in terms of flexibility, but that's okay. We can take care of that too, right? If the entity wants to spend the money faster, that's fine, but maybe it's subject to a DAO veto or a DAO co-approval, right? So this is where you get into a check and balance type of dynamic, where it's a little bit different from the traditional, very centralized, fiduciary duty, regulatory licensing types of structures that we have in traditional finance, but it gets you to a similar or possibly even a better place in terms of trust minimization, reliability, and protection for everyone.
I want to ask, like, do you see any examples currently of DAOs that you think are run very well? Like, do you have, or maybe just points, like maybe just certain aspects of DAOs that are run very well? I'm kind of interested, just like bring this back to something tangible. So maybe I can, go ahead.
Yeah, I think Curve and Lido are run like pretty damn well. I'm working with Lido. I mean, you may have seen we did a Lido Borg, and I think they'll do more. So that'll a little bit formalize some of the things they were already doing. But they're good in the sense that like the stuff that the DAO controls and is supposed to control is on-chain stuff, and it actually controls it, right? Like if the DAO passes a vote that will lead to an on-chain transaction that actually causes the change to occur, right? And I think that is good because then you can legitimately say, whoever these token holders are, they are running something for themselves and they directly control it. They're not relying on intermediaries, right? And in Lido's case, they use Curve only has one multisig, which I'm actually on. It's called the emergency multisig, and it has very, very limited powers. All it can do is it can kill a pool that is, I think, less than 30 days old or younger, or maybe it's 60 days. And it can kill gauges for any pool, Curve rewards for any pool. And so it's quite limited. I definitely wouldn't say it's like a money transmitter or a fiduciary, and like anyone seeing what it can do, I don't think they would think that like I own Curve and, and like looking out for their general best interests. And then everything else is all on chain, right? The mechanism for determining which pools get what amount of Curve rewards or whatever, it's all on chain and it's all directly controlled by the DAO. So I think it's very good. And in Lido's case, they have some more use of multisigs. They use what I would describe as a Borg-like system called Easy Track, where there is a system of the DAO can do vetoes in certain circumstances. And so when there is some centralization, there is a little bit of a check and balance dynamic back with the DAO. And so I think those two are really well done in terms of protocol DAOs. And then obviously there are a lot of things that I wouldn't actually call DAOs, but I think are Borgs, and I think are like have really good legal engineering as Borgs. Like Constitution DAO, for example, was really like an LLC with some things in its documents about when to talk to the token holders or whatever. And I think it was like a well set up Borg. I had set up one called Metacartel Ventures DAO, and I think that was in retrospect, I would have called it a Borg, and I think it was a really well set up Borg. So there are some things, but vast majority of them honestly are a huge mess. I'll be honest. That's also sort of our market opportunity.
Yeah. Okay. Well, this is like sort of adjacent to that. You've been pretty vocal, at least I've seen some tweets from you regarding sort of like some of these projects that have both tokens and equity in how they're designed. Yeah, go ahead. I know you've had like some strong thoughts on this. Like what is your kind of like overarching belief about this?
Yeah, it comes because I did a lot. I went through a stint in my career where I was doing a lot of venture financing deals for DeFi projects on the company side, and negotiating against A16Z and Paradigm and these others, right? And I just saw that. It's one of A16Z, one of Paradigm's lawyers, outside counsels. I remember on one particular deal pretty early on during the DeFi summer, I remember him explaining to me, we want the double dip, because I had some objections to certain things in the document. I was like, what is what the hell? You want the double dip? Yeah, we want the token exit liquidity, and then we still want the possibility of doing like an IPO or an M&A or something like that on the equity. Because I was trying to argue, look, this thing is like a temporary vehicle, this entity. We don't need all these IPO provisions and all these things, because like all the value is going to be in the protocol and in this token, right? And it's going to be completely open source code, right? So there's not really a lot. Technically, there's a copyright to the code, but it's there's not really a lot of proprietary value to it if it's open source, right? And so why do you guys care about this? And I realized at that point that these VCs have this model where they're really going to play a wink nudge type of game, right? They're going to release the token. It's going to be very valueless. No fees are going to flow to it. There's going to be no duties owed by any of the company to it. The company people just owe their duties to A16Z and the other equity holders. But and then you'll still be free to like also run some sort of proprietary business on top and pump value to the equity as well. And the early investors, they get both, right? But the users, they only get the tokens, right? So this is very, very bad. As a corporate lawyer, as a guy who, M&A deals I did for 7 years, they're all about navigating conflicts of interest in exit liquidity scenarios. And to me, this is just atrocious, right? It would never, like if a company had two types of equity, right, that went to like different people and all these things, I mean, it would be, a Delaware judge would smack them down so hard, right, for what these things. But by the mere fact of not giving any rights to the token, but letting people imagine that a fee switch will be turned on one day or secretly, they're not able to talk about it, but secretly Hayden really does want to pump value to the token, and he secretly doesn't really care about his equity. He just only cares about the token. And one day when the regulations are better, they're going to pump the token. That is the hopium that goes on in the minds of retail token holders, and they don't understand that at the corporate level, consciously, it is designed not to be that. Right?
Yeah.
I just think it's heinous, honestly. Yeah.
Yeah. I mean, I think a lot of times the default answer has been, well, we can't do it that way, right? Like it's sort of this, oh, well, we can't allow the token to derive value, so we have to do it like this, right? And I mean, my belief, and not that it matters, but I feel like I've been fairly consistent, like in thinking this way, is that if you have to do it that way, it may be worth considering not launching a token at all or not having equity at all, right? Like, and that's kind of a bizarre concept, it seems, in this space. But like I've always wondered, and maybe I could probably figure this out, but like, why was this ever even allowed to exist in the first place? Like, why were regulators not like, hang on, you can't have like this sort of nebulous, undefined token and simultaneously have an Delaware LLC that like ultimately has, a claim on to the future cash flows of a business, right? Like, why was this ever like, why did this ever come into existence?
Right. I mean, that would be my dream. And for a certain time, I thought that is what regulators would do in the space. That's the Hinman speech came out saying ETH was not a security and talking about sufficient decentralization. And, I thought a lot of these projects that are creating these weird pockets of centralization with these companies and stuff, like they would get dinged for that, and tokens that were more decentralized would be better off. Right. But what ended up happening is that, we got Gensler. And he just hates the entire space. It's just all the same. To him, it's just all just like one giant field of garbage, crap, fraud, right? So he doesn't want to get in there in the weeds and like try to actually help token holders in some way and be like, oh, this is okay, except like you messed up this thing and now there's all this like trust and potential for abuse. It just never even gets to that point, right? It's just like it is all bad. You may notice that when they do get a settlement with a project, the SEC that is, almost always it just involves destroying the project, right? They say to tell the team just destroy all. They don't say tell the team destroy your equity and get rid of your company and keep the tokens and then the problem is solved. No, they say keep your equity in your company, destroy all the tokens you have, right? Because that clearly breaks the common enterprise and makes the whole thing worthless. And obviously people are not going to work on it anymore. So I wish they would do that. I think that would be protecting token holders and protecting retail investors, but they don't want to do that. They want to protect, Wall Street and these traditional models.
Yeah. You've been pretty vocal, I would say, also with regards to like some of the other lawyers in this space and what you view. I think I would, granted, I'm not like so familiar with this domain to be fair, but from what I've seen, I think you take more of a, maybe like cypherpunk side versus some other crypto lawyers. What do you think a lot of lawyers get wrong? Like, what are some of the main things? I don't know. I guess like you were just talking about Paradigm's lawyer, right? So like that would be, but like where do you think that like a lot of crypto lawyers maybe, I don't know, bending the knee, or they just like definitely get some ideas very, very wrong for this space?
Yeah, I mean, lawyers in the space are very interesting because it's a mix of sort of like people who've been around, I think, a little bit longer, maybe like me, who got kind of got in for the cypherpunk ideals. But then Big Law got involved, and they're very much not cypherpunk for the most part. And then there also are just like tons of people who just like see it as their best money making opportunity as a lawyer, and they come in. So there's a why. I don't want to be monolithic about it, but I would say, and to me, I could quibble with a lot of things, but to me, the biggest theme that stands out is doing something that is legally correct, or that a lawyer believes has the best legal positioning, but that is ethically like perhaps the worst thing that could be done, or like close to the worst thing that could be done, right? There's a lot of unethical things that are legal, right? And sometimes structuring something to like maximally protect your client's position ends up in a very unethical arrangement. I think the dual token equity thing is a perfect example of that, right? And so, yeah, that's the biggest thing that stands out. I also do think that there are like just the lawyers should be more informed about the way the technology works. It's very hard, including me. There are areas where like we'll get into MEV in a bit, and I have a little bit on it, but like I'm not, I wish I were much more knowledgeable about all the mechanics of MEV, for example, right? It gets hard, but I think a lot of lawyers don't even try, really. And they don't have like for a long time, like in 2017 and even beyond, even sometimes you still hear this, like I would hear lawyers talking about smart contracts either as being legal agreements, right? And just like you read the code just the way you read the natural language, and it's somehow going to be the same thing as like a natural language text agreement, which is obviously preposterous if you understand the way smart contracts work. I would hear lawyers talking about smart contracts being self-executing, which is definitely not true, like as if they're robots or something, which is definitely not true. People still have to call the functions on them, right? They're purely passive. I would hear a lot of misconceptions even today around miners versus validators, not understand, going with the old language and concepts around Bitcoin mining and just like applying that unproblematically to proof of stake, even though they're completely different. Just many, many things like that, that I think aren't correct, and then lead to bad policy advocacy and bad legal strategy. So, yeah.
I had a quick, like somewhat non sequitur, but you brought it up. What do you think about liquid staking tokens? They used to be called derivatives. Now they're called tokens. Right. Do you think that liquid staking tokens are securities?
There's no one answer. I would say if the backing behind them is, sort of custodial, that is, you've made a deposit with an entity, right? Yeah. You've received this token in return. If that entity is doing what I think, like what I understand Kraken and Coinbase were doing with their staking programs, which is really more of a ministerial activity where they say, look, we're going to take your ETH that you gave us and we're going to, put it in ETH validator, and we're going to take 2% of the rewards. And we're going to give the rest to you. Personally, it's debatable, right? Because there is a pooling that occurs and it is custodial, and there's some efforts. But I personally think, and this is where the technology and market understanding comes in a little bit, I personally think that because everything in the validator ecosystem, there isn't really like a massive edge for any given validator, right? Like they don't have, like Flashbots works the same for every validator, right? Like they're all kind of getting similar MEV opportunities. There's not like a unique business strategy there. It really is, I think, a ministerial, custodial, and staking, service. And so I don't think that's a security. But if they were to say, if they juice it in any way, right? Like if they say, we'll take you just give us stablecoins and we'll deposit it against, we'll split it up against all these different staking protocols in like a good mixture that optimizes rewards, or we have our own token and we stream that token to our depositors or to people who stake with us. Or you start to get into some of these dark forest things, like Coinbase is running some type of off pool, dark pool thing, and that feeds into the rewards that the depositors get, and they're getting preferential transactions through an off-chain route, through like business deals that they have, then that could push it into being a security, right? Because now you're getting much more, something that looks much more like entrepreneurial efforts. In terms of the decentralized protocols, like Lido, Rocket Pool, whatever, I don't think those should be treated as securities, because it's just very, again, there's even less there that is entrepreneurial, right?
Yeah.
It's just very standard. It's all on chain. It's all transparent. There is a separate issue of whether such tokens may be, even if they're not securities, they may be commodities, what's called commodity swaps, which is an issue that hasn't really been litigated or even really analyzed very much. I wrote a concept paper on liquid staking before liquid staking was a thing with Horus, which was a big, validator. Yeah. And that I had flagged that issue back then of like, are these things possibly some type of swaps? We don't know, because if they are swaps, they're like swaps that work without contract rights, which is kind of a weird thing. But, so that's an additional, risk with them. Yeah.
Yeah. Okay. I've always been sort of curious about that. Okay. I want to ask you then about MEV. I read this paper recently that I don't know who released it. You probably read it though. And it seems like the feds have a decent understanding of what's going on. I was surprised. I think a lot of us, granted, I'm not as in the weeds, but I think a lot of us have been consistently surprised with how much they know about what's going on. Though the most recent MEV paper was like sort of in relation to OFAC transactions, sanctions, and then Tornado Cash, and sort of like the impact that that's had. What was your like takeaway? And then maybe if you want to just go into MEV in general.
Yeah, well, I think that there was a recognition. The issue of Tornado Cash is different from MEV, I would say, right? But they both relate to the validator ecosystem, right? The validator, builder, proposer ecosystem. And I think that there should now be an awareness from authorities, unfortunately, that there are these centralized points within this ecosystem. And if you just get, there's like four right now, main ones. It's like Flashbots, I forget the names of them all, but basically almost all of the well-known, like sort of venture-backed ones, they all censor Tornado Cash transactions now. And now there's like one that I think no one knows who it is and isn't venture-backed. Or I mean, obviously some people do, but I don't. Maybe most people don't. And it's at the top of the list of letting in uncensored transactions into its block, letting in Tornado Cash transactions. And I think authorities will now realize that, right? Like whoever that fourth or that fifth one is, they got to get them somehow into the system. So they will censor too, right? And so then there's this whole dialogue around inclusion lists in Ethereum to try to solve this choke point, right? Which I think is probably really important if Ethereum wants to not be captured by nation states. So they're interrelated in that sense. But the real thing with MEV specifically is that, it's stuff that would never be tolerated in traditional finance markets. It's front running, and it's, Robinhood, like the SEC is going after Robinhood for like doing a very, very limited version of the same thing that is like clearly good for consumers, but is like such less value capture and abusive than MEV is, which is just like selling order flow, to Citadel. But with MEV, it's all that stuff on steroids, right? And so, if it shows, unfortunately, there was this woman named Angela Walsh. I think she sort of pivoted. She was a law professor for a long time, and she used to argue way back in the day that Bitcoin miners are fiduciaries to Bitcoin holders. She would also argue that Bitcoin core developers were fiduciaries to Bitcoin core. And I always thought that was completely wrong, right? Because what miners do is so limited and all these things. But now, actually, with this new ecosystem, her arguments could make a certain amount of sense, right? Because these things are in a position of trust. They can screw over users, right? Users have to, and so when that happens, if we don't build better mechanisms that reduce those trust assumptions, regulators are going to come in at some point, for sure. And they probably should, because it's abusive. And you wanted to talk about the Avi Eisenberg thing at some point. There's a connection here. There's a connection here with that, and with white hatting and black hatting and all these things, because some of the biggest MEV windfalls to validators are from exploits, because the hackers are willing to pay huge amounts of money to move fast, because guess what? It's not their money. So they just want to get whatever they get. Whatever they get, it's going to be a lot more than they previously had, and they never should have had it in the first place. So they will massively overpay, right, to get their transaction in first, right? And so there's huge MEV there for the validators. And what's surprising to me is that in the Curve exploit, one of Coinbase's validators was the beneficiary of a huge MEV. I think it was like over $1 million. I think it was the biggest ever, actually. Yeah. And they were approached to say, hey, you should give this back to users. Like, this was a crime that occurred. You're benefiting. And they, somewhat to my surprise, and again, this would be another example of where legal advice radically departs from ethics, right? I'm sure their lawyer said to them, if you give this one back, there's no distinction in principle between this and anything else, and we can't keep MEV ever again, and we're basically admitting we're intermediaries, so don't give it back, right? I'm sure that was the conversation that occurred. And whereas anyone with a brain, with a basic sense of ethics, would say, of course you should give that money back. You shouldn't keep that money, right? Like, the user's money was stolen from you, so someone else stole it, right? It's like being in between. It's not a Robin Hood thing. It's like being in between. It's like if you're like standing on the street, and there's a bank robbery, right? And then like the robbers like drop one of the bags of money because they're in a rush to get. It's like, it'd be like, oh yeah, he dropped it, I could just pick it up. It's no, of course not, right? And so, and anyone with a brain and a sense of ethics and a sense of law, who is not going to accept this situation for very long.
Yeah, Coinbase never ended up giving that back.
No, I don't think so. No.
Yeah, that's interesting. I remember hearing you maybe a couple years ago now on a podcast with Collins Belton, another good guy. You said something that was like very poignant at the time. I thought, well, maybe I very much agree with it. That's why I remember this. And you said, ideally with these systems, and you can sort of extend that however to whatever you want in crypto, but like ideally with these systems, we have some type of rules that are put in place, and then once those rules are put in place, those are the rules, and it's sort of like this opt-in system, right? Like, we as users opt into this, but what happens. And I think this was with regards to the Avi. I think that was the context of the interview was the Avi Eisenberg and Mango incident. Like what are your thoughts on this? I guess this is Borgs are to some extent an attempt to address this, but how do you feel like this idea has kind of played out in crypto? Like, we're opting into these systems, but then a lot of times when we don't like them, we kind of change the rules or figure out ways to circumvent them. Go ahead.
Yeah, that's the issue. I mean, we're kind of our own worst enemy in that sense, right? Because, we have this mantra of code is law. And then I think it's a lot of times it's from people within the community who don't want to live with the costs of their decisions that end up running to the legal system, but not always. I mean, in the case of Mango, I think that was just the government, just coming in, because the users were made whole, right? But yeah, I mean, it's a big problem, this idea of, because look, you can look at DeFi systems. I would say they function analogously to a lot of legal arrangements, right?
Yeah.
So when you have something called a credit protocol and you say people are borrowing and lending out of it, it's very natural as some boomer federal judge or some prosecutor or whatever who's not in the crypto world to just treat that as being the same thing as a traditional lending arrangement with a bank or something like that. In my opinion, this is just like very, very mistaken, both legally and from what is a matter of good policy, right? Because it's not that, right? Like, part of the Avi case, and he had a great lawyer, Brian Klein, who argued his defense very capably and with quite a bit of technical knowledge, but it's so technical it goes over the jury's head. But the with the prosecution, and there were two aspects to the case. One of them I have no objection to, right? Which is that he committed market manipulation, right? He pumped the price of Mango tokens, and that was part of the chain of executing his exploit. I take zero issue with that. Obviously, it meets the definition of it, and all that. I get it. There was a second component to their case, and this is where they were able to get most of their toughest remedies from, which is fraud. Right. Now, there could be many ways of arguing that what he did was fraudulent, and some of them I would hate less than others. But the particular way that they argued that he committed fraud, I think any actual DeFi user would understand is totally incorrect, which is that they argued that anytime someone deposits assets into a lending protocol and borrows money as a result, that they are making representations that the assets are at that the price of the assets, as recognized by the protocol, is an accurate price or accurate to the value of the assets, and that they intend to and are able to repay the loan that they are taking. That was basically an aspect of the prosecution's argument for why Avi committed fraud. And they analogized it in a very meat-headed way to traditional lending. When you go to a bank, if you represent and you put your house, like you are representing that is the actual value of your house. You are promising that you will repay the money, right? But in DeFi lending protocols, there is absolutely no promise to repay the money. And everybody understands that. Right, you have the collateral, and if whatever that is worth to the protocol at the time is liquidated, that may be all the protocol gets, and it's fine. That is within the rules, right? And there also are no representations made, right? It's not like you're trying to. Who fucking knows how much Mango tokens are worth, right? He did manipulate it,
zero,
but the manipulation was wrong. But there's no second step of telling the protocol, telling the DAO or whatever they said that it's worth this much money. That's not true. No one makes that representation. So I take major issue with that. And if that's the way we're going, DeFi will just be destroyed. Every protocol will basically just need to be in a legal arrangement with like representations and warranties exchanged and all these things. And what happens with the code will never be the final word. What was supposed to happen with the code, according to some legal understanding, will be the final word. And that would just loses all of the benefits of this technology: the finality, the speed, the reduction in ex ante and ex post due diligence and transaction costs, the reduction in potential for post hoc disputes. All those benefits will be gone, and it will just be swallowed by the legal system, right? So that would be a terrible, terrible outcome. And then there's sort of like yet another element, which is like if we start punishing all these white hats for things, then ultimately we won't have this Darwinian evolution of protocols that comes from them getting hacked, right? And so if you believe that it is possible through this Darwinian evolution, which I think clearly has been shown, that the smart contracts are getting better, right? Yeah. And the hacks are getting, less in terms of like at least quality projects. Like if you start punishing these white hats for these things and don't provide a system for them to do it legally, then people are just going to get lazy, and again, the legal system will swallow it because you just go to court to get the outcome you want. So one thing we did with Samsung and Paradigm and this organization called Seal.org that they formed is we created a white hat safe harbor agreement that protocols, not really protocols, but people involved in protocols can adopt to try to say, hey, if you want to white hat our protocol, do it like this. Send 90% of the money back, keep 10% for yourself, no questions asked, we're good, right? We give you a release, all that stuff. So I think that's an important thing. Yeah.
Thanks for listening to The Gwart Show on the Blockspace Podcast Network. Subscribe to our newsletter at blockspace.media to get the show directly to your inbox. Show links, transcripts, and Bitcoin articles twice per week. Stay ahead of the conversation by visiting blockspace.media.
How much do you personally view the difference between a governance attack versus a code exploit? And maybe Aave is a decent example of this. Like I think there's others, like even the most recent Aave curve drama is like sort of interesting to me. But I think a lot of people view, exploiting a smart contract and stealing the funds is probably fairly close to being pure theft. Conversely, we saw recently with something like Compound, these people are following the rules, right? Like they're using governance tokens, and if there's a way to benefit from doing this, so how do you view like the distinction here, and like maybe going forward with regulation, how do you think that this should be thought about?
Right. Well, I come from the M&A world. And in M&A, this is a very, very familiar issue, right? There in the traditional equity markets, there's what's called shareholder activism, where like Carl Icahn buys like a large amount of stock of some company that he thinks is underperforming and tries to get a board seat or whatever, tries to get changes made. And it's usually very bullish for the company when someone like that, these days, when someone like that comes in, the stock price usually rockets, as long as they have a plausible approach to it. And a lot of these things have been huge success stories for shareholders. Now, I'm sure if you're sitting if you're the board of directors and management of a company and you read the 13D that was filed that Carl Icahn has acquired 5% of your stock, you're saying to yourself, fuck, it's a governance attack.
Yeah.
Right. So from your point of view, it's an attack. But from the point of view of all your pissed off shareholders who are mad at your underperformance, it's like the best thing that ever happened to them. Right. So it's extremely subjective. And that is, and by the way, Carl, this works relatively well now. It's reached a stable equilibrium in the public equity markets due to a mix of legal structures that were created to address things. But way back, if you rewind, this situation looked a lot like what we have with DAOs now. There were no rules around it. And instead of it being called shareholder activism, it was actually called greenmail or it was called raiding. Right. And it was a much more brutal, no holds barred thing of like, hey, we're going to fire all you guys. We're going to take over the company and burn it to the ground, unless you do like 300 million dividend or whatever. Right. And so it evolved over time. And so I think we are in that very early stage where there's very little understanding around these types of issues, which, when is it a good thing that someone has come in to try to create a change of direction through voting powers of the tokens? When is it a bad thing, right? And what sort of disclosures should there be around it, et cetera? But I think in theory, it's a very promising thing because, it could kind of mean that DAOs really become meaningful in the sense that if there's untapped value there, someone who's able to tap it is able to come and buy a stake and generate an enormous profit for them and everyone else, right? And I think Borgs will play a role in this because, like, the resolution of the compound thing ended up being that they would in fact take a bunch of compound out of the DAO and go and stake it in some protocol, but they were going to set up a smart contract that somewhat limited, what they could do with it. And it was Borg. I would do it better, right? I would put it in a legal entity. The checks and balances would be a little bit more clear and stuff like that. But it's the right direction of, okay, yeah, we can use these tools. We can use a multi-sig that's programmed in a certain way to actually create an equilibrium between, a central among a broader DAO, some other people who are working on it, and one set of token holders who want to push it in a certain direction. And we can create these nice equilibriums. And I think ultimately it could really flourish into like a new cybernetic economy where there's much less mismanagement, much less information asymmetries, and many more people have a stake in the success of a lot more enterprises.
Yeah, I wanted to ask you specifically about L2's multi-sigs as of late. I saw something interesting the other day, which was, I think this was in regards to Arbitrum and their security council. And I thought it was quite interesting because Vitalik actually tweeted and said, look at the security council of Arbitrum, right? Like, and all of us can go and see who's on the security council. And we see these are all, respected, high standing, probably, ethical members of crypto, at least, to the extent that people know who these people are. But what I found interesting is like the idea that these people are going to rug users on L2s to me is like very, very low probability, right? Like they all have, once again, reputations, they have stake in these L2s. The likelihood that they get, greedy one day and just decide to, co-sign a 4-step multi-sig or something is like, okay, no, I don't think that's ever going to happen. But what's interesting is that Vitalik pointed at this and said, like, look at these high moral standing characters, right? And I'm like, these are 7 people that it's very easy for Gensler to go directly after, right? And I'm curious, like, your thoughts, maybe, just because L2s are quite a popular subject right now, I look at these and I'm like, this is not the kind of like, this is not the win you think it is, right? Like in many ways, you're pointing out exactly who to go after to change the rules on people, right? I don't know. Yeah, so go ahead. That's just some random.
So, by the way, when is this podcast getting published?
Tomorrow.
Okay. So so a day from the day that it gets published, I think, you will see a new governance arrangement that addresses a lot of these things. I won't say what ecosystem, but and it represents a lot of my thought. Obviously, not only my thought, but of ways to address this. But at a higher level, the thing that is missed in that is that you're not only trusting those people, right? You're also trusting everyone who could ever make them do anything, right?
Exactly.
And they're very gettable, right? And so we have this. So like it's not the best trust model, honestly, and people kind of ignore that type of issue around it. It's also not great for those people because they're not wrapped in an entity. It's not clear like what the principles of their decision making are supposed to be. I think like implicitly we have this very crude off-chain governance and trust model in crypto where basically like we say, okay, well we stake ETH to trust validators, right? So, or validators stake ETH to get us to trust them. So like when it comes to off-chain things, we'll have people stake their reputation and we'll trust them for that reason. And it's just very, very different for a variety of reasons. Number one, like faults are less attributable. Right. So like someone can always just say, well, it was the best decision I could make. Like, so the slashing, it's less attributable and therefore like the reputation slashing is less certain. Right. And so the cost is less clear. So there are all kinds of things like this. But I do think that even though there are these issues, there also are like reasons why these types of multi-sig arrangements exist. Right.
Yeah.
And so like, I used to be like a really decentralization maxi. And one of the things I learned the more I really got into weeds with developers is like, they think it's crazy to make things too decentralized and irreversible, right? Because they are software engineers and they know that software is never completely secure and never final, right? And so I do think that there is a place and probably a permanent place. Like I disagree that one day all these multi-sigs are just going to totally disappear. It'd be nice. I think that'd be optimal, but it's so hard to figure out every contingency and everything. So what we need to do is we need to get things to the point where the multi-sigs don't have too much power, but they can come in. Like the benefit they have is that they're faster and they're more decisive. Right. So like if you have a bunch of security experts on a multi-sig and there's something that looks like an exploit, yes, they're experts. They should just go and turn it off. Just do whatever they can immediately. Yeah. It shouldn't be a DAO process. There shouldn't be a government regulatory process, right? It needs to happen now. And they're experts. But I don't think reputation is enough. I really don't, because they still could conceivably abuse something. So there also has to be accountability. And I think you need something that looks like law to have accountability. So if they are, even though it's very, very unlikely, I agree, it's very unlikely that they would all collude to steal funds, but you could get into scenarios where things are a little bit more gray area. Like someone has we're seeing this stuff with Eigenlayer and the ETH Foundation, right? Like a lot of these ETH Foundation core devs now are like theoretic on paper, at least, are super rich in terms of EGAN. And you could just imagine situations where like there's a choice between something like something you could do with Ethereum that really screws over Eigenlayer, but helps a lot of other people, right? Or like has a very high probability of like helping everyone, but totally screws over Eigenlayer. And then there's this other scenario where there's still a good probability of helping everyone, but it's less strong. But in that scenario, Eigenlayer also has a chance, right? And you can see how the incentives will skew toward that scenario, as opposed to the one where Eigenlayer is dead, but almost definitely everyone else is fine, right? And so you need to set for these committees, you need to tell the people, and it needs to be clear to everyone how they will decide these things. Will people with these types of conflicts of interest be allowed on? Is it okay as there's just a minority of them, so it's okay, and they disclose it? Then what happens if they don't disclose it? Well, you need a way to punish them, actually, right? Like, you can't just rely on this reputation thing, because they may already be rich enough from burning their reputation that they didn't care, right? Yeah. So these are the types of things. But I do think it's here to stay, and I don't think it's like a solution to just go like max total decentralization from day one, because people are going to lose a lot more money. I do believe that.
Yeah, I wanted to ask you one last question on L2s. Do the existence of single sequencers, does that concern you, at least under the current regulatory landscape? What are your views? Like, are these money transmitters, which a lot of us have kind of
it's hugely concerning.
Yeah,
it's hugely concerning. I don't want to express too strong of an opinion, but it's a major legal attack vector, and it needs to somehow be fixed. Yeah, and that gets into the MEV point again, right? Because
exactly
benefiting from MEV, but also just nuts and bolts, like money services business stuff, broker dealer stuff, whatever it might be. You know, it doesn't look great.
Yeah. Okay. In your Borg paper, you talk about tokenizing securities. Do you think are the differences maybe between tokenized securities and then Uni token or Aave token, or the long run? Will there be two different kind of versions, or are we headed towards everything as a tokenized security or nothing is a tokenized security under a certain regulatory, framework? I just like to hear
there'll be two versions. Like if you just looked at US law, you would think that everything's going to somehow end up all being the same thing. But I think, we have Europe, and we have this MiCA framework, which very clearly, sets forth what I think is a pretty logical framework, right? Things that are based on contract rights, right, for the most part will be deemed either securities or some other type of instrument that they call like asset reference tokens, or custodial stablecoins. And then things that are not based on contract rights, they're just purely based on system authorities and system powers, so to speak, are in a different bucket, the non-securities bucket, right? So what a tokenized security would be is a token that, as a matter of a written contract, represents a certain set of transferable rights, legal rights, right? And there are different. My sort of mental model for the best way for that to be is really to think about the token as a certificate, right? In the traditional finance markets, the markets used to run on paper stock certificates. People would run around and they would like endorse them over to each other to do a sale or whatever. That was very inefficient. So we moved to a very, very centralized model, which is the type of thing that Wall Street Bets rails against a lot, where basically all the stock is ultimately, like, Apple's only shareholder is really a company called Seed & Co., right?
Yeah.
And that holds the jumbo certificate. And then there are these sub-rights that like flow down to all these broker dealers, and it's this whole ecosystem. And it really means that there's no immediate connection between like retail investors, for example, and these actually huge companies, even though they're called stockholders. They're really not stockholders. So the cool thing with tokens and all this technology is we actually could, in theory, go back to that certificate model, but now it would be scalable, right? If every token was a certificate, right? These things can trade like crazy. You don't have to run around signing them, handing them to people. You could do it on chain, right? So to me, that is, in terms of a public equities market thesis for why these things should exist and how they should be designed, that to me would be the value proposition there. It's obviously very, very hard to get to that because there are all these vested powers and players and regulations and all these things. So I think that's going to be hard to do. I think what people can do in the meantime, though, is we do have, private securities, right? And so like the tricky thing is that like a lot of the tokenized stock dialogue and tokenized securities dialogue has always been emphasized around liquidity, right? But if it's going to be liquid, it's going to be public, and then it's going to fall under all these regulations. So I actually don't think liquidity is the main play here to start to bootstrap to the bigger vision. I think the way you bootstrap to the bigger vision is start using them as, start getting startups to tokenize their equity, right? And advertise the governance benefits of this, right? The simplification of the financing process you can get from this, the simplification of the M&A process, right? Because if you think about a typical venture-backed company with like Series D, Series C, Series A, and there are all these complicated written rules about how the funds flow, if there's a payment or whatever, and the relative priorities. I mean, all of that can definitely be programmed, right, into a smart contract. And then you could just push a button when it comes time, and the money will just flow the right way. And you don't have to pay lawyers $1 million to do your M&A event anymore, right? You still probably need lawyers involved, but it's going to be less, right?
Yeah.
And so to me, if we do the tokenized stock stuff at MetaLeX, it's going to be around that. And again, basically you're creating cybernetic entities, just this time around securities rather than DAO tokens.
When you were talking about signing certificates over, like on paper, is this sort of a return to bearer assets? Like, is this kind of what you're getting at here? Do you see a future? I don't know. I mean, I think there's probably two different futures. One you may see like pragmatically, and the one you may see more kind of optimistically. But do you see a future where a lot of these bearer asset laws are kind of done away with, and there is the ability for somebody, non KYC to own a tokenized security, and allow it to flow on these rails without any, kind of intermediaries?
Right. Well, a certificate is not necessarily a bearer security. There are bearer certificates and there are non-bearer certificates. If it's made out to the holder, quote unquote, then it's a bearer certificate. If it's made out to Gabe Shapiro, then it's a registered certificate, right? So I think you could do something similar, with tokens, where they have as metadata, the sort of mutable metadata, the name of the holder, right? So there's not an intrinsic incompatibility there. But to answer your question, the entire world of law and tax is united against the notion of bearer securities. Yeah. So if anything, I would bet that we may have a problem with tokens being bearer assets and needing to somehow get those rather than securities somehow coming more into the token regime. But I think there is still a lot of cool stuff you can do without having bearer securities. And I'm also excited about ZK credentialing type of stuff, right? Now, this is not currently an acceptable legal approach. Like it's not actually like most compliance due diligence requirements don't actually permit a person or a company to rely on the due diligence that was done by some other company and just piggyback on it.
Yeah.
But in theory, I don't see any reason why regulators and governments shouldn't over time get more comfortable that can be a thing, so that you don't have to know the person, but you do know that some other credentialing authority knew them and checked those things. There's a little bit of risk around, like, okay, did the person sell their private key off chain, right? But that's not a super scalable thing either, right? So like selling private keys is definitely not super scalable because, the seller may always have retained the information. So, so I do think you could get to sort of a compelling mix of things, and we want to play in that space. Yeah,
I wanted to ask you one other point. You've been talking about business source licenses recently, and I don't know if you have some objections to those, but like, what do you think about a lot of these projects now launching with BSLs and sort of attempting to create maybe more of a moat than a lot of us initially thought was like maybe the vision here?
Yeah. Well, crypto's getting corporatized. There's no question about it. But, and to me, I'm open to that. But I think in the particular case of smart contracts, it's actually very, very silly, and it's not a moat. And I think a lot of people misunderstand this because they don't fully understand IP law. The case that I hear for BSL, or here's like the non-evil or like non-moat seeking, rent seeking case for BSL to steelman it is like, look, people come and copy paste the code. It's usually a very low effort thing. It's usually some sort of scam. They're just copy pasting it. They're not adding any kind of new innovation on top. And we want to stop that. I get it, but that is not the only thing. That is not the only activity that is chilled or prevented by a proprietary IP model, right? And the so there are two things. Number one, just from like, if you're kind of an accelerationist, you want people to experiment as much as possible and stuff like that. You want people to be able to, like someone who comes along and looks at the Uniswap code to say, hey, I think by making these like 10 changes, I can make something much cooler. And you want them to the ability to do that. And Uniswap doesn't want them the ability to do that, at least not permissionlessly. You could go to Uniswap and get a license or something potentially, right? Or in their case, you could go to the DAO because they flow the things through the DAO. But the bigger thing that is, and look, I'm even fine with saying we just don't want people to do that. We don't want people to release new and improved versions of it. Okay, it's a values thing. What really gets me as a lawyer who advises projects and sometimes has to advise them on this very issue is when is actually, because there nowhere else in the world do you see a combination of a proprietary IP model combined with the code being source available, where everyone, and what is actually being created from a legal IP point of view is what I would call an info hazard. Because how does Google prove that it didn't copy, that it didn't breach someone else's copyright when it's writing a functionally similar application, right? And there's some other software that's out there that maybe at some point Google had access to through some licensing arrangement or something. How does it prove that it didn't breach the copyright? It hires people who have never seen that code. It only lets them work on the new code when they are in a clean room at Google's offices with lawyers there and a bunch of supervision and them going through metal detectors and shit on their way in and out, right? And they use these clean room. That is the only way they can be sure that they will not end up and potentially lose a copyright litigation. Because it's not just copy paste that violates copyright. If I look at the curve code is not open source. If I look at the curve code and I then go and code a similar thing, and there's some possibly coincidental or possibly somehow influenced by my unconscious memory similarity between the two, I may have violated copyright, even though I didn't copy paste anything, right? So it becomes an info hazard. And that is the aspect of things that, like, when I talk to very fearsome, like DeFi founders who seem to hate me on this issue, I just can't seem to explain to them properly. And VCs, they just don't seem to get this aspect because it hasn't played out yet. No one has. They're just like, well, we wouldn't sue over that or whatever. Well, how does the new developer know that you're not going to sue them, right? Like, they're just trusting you for that. And then, like, how are they supposed to get investors? Like, the investors are doing thorough legal due diligence. They're subjecting themselves to a risk in this. And so it does, I truly do believe it does chill innovation, because I've seen it chill innovation. And they just say, no, we just don't want people to copy paste. But it's a much, much bigger issue. And the other thing is that, of course, smart contract developers are few. Everyone's looking at everyone's code. So like, even if you could afford as a new project to do this clean room procedure, which you can't, of course, but let's just say in theory you could, who the fuck are you going to find that is good at programming smart contracts that's like never seen the Uniswap code? You know what I mean? Right. Like, it's just an impossible thing. So that's why I don't like it, regardless of norms and everything else.
Yeah, that makes sense. Okay, well, we have to talk about politics a little bit, and you are helping World Liberty Fi. What is the idea behind World Liberty Fi? This is Trump's new.
Yes.
I don't know if I should say that. Go ahead.
Yeah. So first of all, I am not helping. Actually, we have MetaLeX has a tech company and it has a law firm. As part of the law firm, there are 3 partners. One of them is my MetaLeX co-founder, Alex Golubitsky, very good attorney. Has a lot of DeFi clients. Had like a long international tax structuring career before that. That is his client, right?
Okay.
And we're decentralized in a certain sense in that any partner can bring in a client. So I don't know many details. I basically know the same details as the public, which is that it's supposed to be what I originally heard is it's a smart contract that will take in funds and deposit them into Aave and maybe have a governance component so that maybe future other DeFi protocols could also be added in the future. I don't know if that is still the model today, to be honest. And that there will be a governance component, and that there will be a DeFi component, and that, it's somehow based on Aave. What I'd understood is that it would be Aave itself, like the actual, the thing that everyone uses. I'm no longer completely sure that that's the case. I've heard some different things about that, and I'm not personally involved in the advisory relationship, so I don't know. Okay. The long story short is I don't know. I think it's cool that Trump is involved, but obviously, and is like bringing out DeFi, and so like it'll get attention. I think it's cool that it's Aave, which like everyone hugely respects and thinks is very secure. But the devil's in the details, of course. So I hope they do it well.
Yeah. You seem to be pretty optimistic though about Trump and crypto versus Kamala and crypto. Like hypothetically, what is like I think you've made some points that I think a lot of us generally agree with, which is like, we have one guy over here who's launching NFTs, and then we have a history of an administration that doesn't want us to launch NFTs. It's like pretty straightforward. But yeah, what is your sort of read on like the future under, I don't know, crypto under Trump maybe?
Sure. Well, so there's a broader context here, right? Which is that under this Democratic administration, people see the attacks and stuff, and that's sort of intuitively obvious, and that it's bad and all these things. But what has happened in parallel with that is a massive empowerment of law and policy power brokers in DC that have become deeply imbricated into the crypto ecosystem. And I would probably say, weirdly enough, have become the most powerful and influential people in all of crypto. So there's been as part of this, there's been a huge transfer of power from developers, coders, degens, whatever you might want to be, into lawyers and policy people in DC. There have been a bunch of legislative proposals that have come out of that. I personally think they are all basically trash and very bad for crypto, but some of those proposals could be very good for certain powerful players in crypto, right? Like, I think if FIT21 passes, I think that would be like, I would want to own coin stock on that day, right? Because I think we will get Coinbase 5 for life. It's like a dual market structure, dual SEC, CFTC supervision of the market, all these different licensing requirements that could apply. And, a lot of people look at that and they say, oh, it's good. It's clarity. We just need clarity. They don't understand the way these things work. The CFTC is not going to give out 5,000 licenses. They're going to give out like 3 licenses, right? And Coinbase will be one of the ones that gets them. And then, this whole regulate apps, not protocols thing, that'll be the same thing. Every front end, every web app, probably even including block explorers, unless they're totally nonprofit, will have to have some, or they don't have wallet functionality, will have to be filtered through some licensed entity. And so I think what would happen is basically, Coinbase becomes the app store, for all of crypto, right? And has the license and filters things, right? And then there will, of course, always still be a degen element that's like basically violating the law or arguably violating the law. But it really becomes, from my point of view, a bad thing. And I think we probably would get that if Kamala wins, even though, like, so some people would be like, oh, we're worried Kamala will be so hostile she won't pass FIT21. I'm like, no, I'm worried she'll be just hostile enough that she'll pass FIT21, right? And I think what we would get with Trump is more the vision that the pre-Gensler vision that a lot of us had who've been around for a while, which is that what we always thought would happen and argued is the case, is that the SEC has, the CFTC has, they have sufficient exemptive authority and ability to write regulations inside of those agencies that they could write something that works decently well for crypto, right? And like maybe respects the things that are, peer-to-peer as being peer-to-peer. They're kind of outside the licensing framework. And then things that are more centralized or custodial or whatever, that those are subject to the regulations. I think with Trump, we would get we'd be more likely to get to that outcome, because I think he'll make someone very crypto friendly ahead of CFTC and someone very crypto friendly ahead of SEC. And they can if we get legislation, it's always going to have a dark side and a major downside to it. So for me, the best bet is get in crypto-friendly regulators. It's not the most democratic, I'll admit, in a certain sense, right? Because it's not going through Congress. But I think it could end up being a much, much better outcome for crypto and a much more free state of affairs that doesn't just reward these vast corporate incumbents. So that's really why I'm betting on Trump. He's no friend of Congress. He's not going to want to do these things through Congress, and he's going to appoint crypto-friendly regulators.
Yeah. Do you think that the crypto community, maybe more like crypto Twitter people, have been misled to some extent about the lawyers in Washington fighting for us, right? Like, I think this is sort of a layup question, right? Because you kind of answered already, yeah. But I've obviously felt the exact same way, right? Like, everyone talks about how great it is. We have these lawyers in Washington, fighting for us, and everybody add the little, the flag by your name for Coinbase, right? And I'm like, there's no way that they have the same vision that you guys have, right? Like, right. And it does seem to have co-opted a lot of the, I think, groupthink in a sense. And you see how much funding this cycle has come from crypto. First of all, it's absurd because half of the political funding this cycle has come from crypto, and I don't know, maybe 1 in 20 Americans are going to the polls with any knowledge of crypto. So there's a little bit of a mismatch there, but yeah, it is it's somewhat hard to reconcile this, right? I don't know that the people fighting in Washington are fighting for what we care about. And in a sense, I don't think it's unreasonable to say that they could be fighting for something much worse than not fighting at all. I don't know if you have thoughts on that.
Yeah, I mean, I agree with everything you just said. There's a lot of psyops, and it's very easy to psyop crypto people. They're some of the most easy psyopable people, I think. And I have in my bio now anti-psyops, because I almost feel like on social media, this is my job, is to try to push back, because I'm not in that circle, and I, by choice, I'm really. So someone posted, Marvin Amori, who used to be GC of Uniswap, he posted a hit piece about me saying, no one would talk to me, and I'm not in these circles. No, I don't want to be in those circles, right? Because I don't like those types of people, and I don't like what they're doing. But it absolutely is a psyop, and it's so easy because these things are so complex, and it's so easy to mislead people. I'll just give you a quick example. In the FIT 21 bill, and there was something Hayden had posted about this, there's some language that it says something like, nothing in this bill will will create an obligation to cause someone to be licensed just for deploying software, or something like that, some language like that. I can't remember exactly. And this was something that Hayden from Uniswap was like, see, it's good for DeFi. It's good for DeFi. It says this bill, guys. all of the CFTC commodities actions are all based on the Commodities Exchange Act, right? And they have everything they need, right, except a big budget. And sort of being seen as the big crypto regulator, to they could completely destroy DeFi. I'm telling you, they almost everything, but even Uniswap itself, they even had an action against Uniswap, right? And they chose to just make it about the web app, but they could have been more aggressive and said that their case would be weaker, but they could say, hey, since you deployed this protocol and it has these leverage tokens on it, you're violating the CEA, right? But all of crypto involves leverage. All of crypto arguably involves swaps as well. Perps is the future of DeFi. Perps are probably, the CFTC would consider them to be swaps, and none of those issues are solved by the bill. And so everyone keeps saying this would bring clarity. No, it wouldn't. And then they don't look at it wouldn't bring clarity over any of those issues, certainly. And then they also don't realize all the ambiguities and complexities within the new language, which will also all get litigated over time, all these questions, right? So it provides clarity to a small number of things, but it leaves a bunch unsolved, and then it opens up a bunch of new ones, right? And it's just very, very hard for non-lawyers to understand this, particularly when they're hearing from authorities like Paul Grewal at Coinbase, who's very revered and trusted. He says it's good, and Hayden says it's good, so it must be good, right? But it's not, and they have very, very indifferent incentives from a lot of us, right? And yeah, that's it.
Are you optimistic about any of the stablecoin legislation? And what do you think of sort of how this has become maybe one of the primary talking points as of late?
Yeah, I mean, stablecoins are going to be in a very tough spot. It's going to be the most regulated thing in all of crypto, most likely, right? Because, and it probably should be because it's custodial, right?
Yeah.
Europe the EU through MiCA is taking a very hard line on them. It's kind of looking like, probably for the most part, they really just intended banks would be able to issue them. Circle, obviously, they're so huge and influential, they'll be okay. But there's not going to be, I think, a lot of room for innovation, right? Because basically these things have to be regulated like banks. The main question is really whether there will be any type of wiggle room. And when I used to be alarmist on this, people would argue that there was a lot of wiggle room for, things like DAI, or what I guess now, what are they calling it now? Sky, or I don't know. But
yeah, Sky now.
The things that are more, DeFi based. And it really depends on the wording of the legislation. There was some early ones that kind of seemed like they weren't covering it. And I just said, guys, there's no way this will be the final version. It just makes no sense, right? Like, why would you allow like a massive loophole? And sure enough, in the more recent versions I've seen, it's much, much tighter, and I don't see a way that decentralized or like semi-decentralized stablecoins, would really be able to work in the United States. Some of them even say that even if you're not based in the United States, but your coin is pegged to the USD, that the US stablecoin reg will strengthen it. But overall, look, I think as someone who blew up in Terra, right, I was interested in I thought that there was a real need for a decentralized stablecoin for these types of reasons. But what I've realized is decentralized stablecoins just either have fundamentally faulty mechanisms the way UST did, or they have massive, or they're just very trust-based, right? They use Arda to be, or they're non-scalable. Like Liquidity, something that's crypto collateral only is probably going to have a ceiling on how much it can scale, right? So there's kind of these three things. And so custodial stablecoins are the winner, clearly. Right?
Yeah.
Got USDC. And clearly there's so much trust involved in them. And they're also systemically important to the economy now as a buyer of treasuries. I mean, I don't actually think it's unfair that they be heavily regulated. I just hope we can keep it flowing relatively freely on chain without subjecting everything to like a massive KYC layer. And I think that remains unclear whether that will always be the case. But yeah.
On that point, I said that was my last point, but this is the actual last point. You've talked a lot about stablecoins and Ethereum forks. What are your so I'll just give a brief overview of what I think your thoughts are, which is that USDC decides Ethereum forks now. Okay, yeah, go ahead. I won't put words in your mouth. Go ahead.
I wouldn't say it decides. I would say it's like could be potentially a very strong influence over, right?
Yeah.
And it gets back to what I was saying earlier, where it's like there's very little recognizance of the way power is distributed off chain in relation to blockchain systems. And there's a very naive sort of brand of apologetics that says, well, anything that the devs do that you don't like, just fork it. Just fork Ethereum. Just fork these things, right? And that is probably true of Bitcoin, that you could always, just because there's nothing built on top of Bitcoin. It's just Bitcoin.
Yeah, it's
right?
hard to as well.
And if it's built on top of, it's not really, it's on the side of it. It connects up to it, but it's not like there are no real world assets on Bitcoin, right? But once you have something where there are all these interdependencies, right, it no longer becomes freely forkable. Like, for example, let's just say this actually happened with Ethereum. There was like an upgrade that bricked all of Aragon's smart contracts, right? I mean, to me, that's now the naive response would be, well, Aragon can just stay on the old fork, right? Well, that's not really true, though. I mean, it's not going to be Ethereum, number one, because the ETH Foundation owns the trademark to Ethereum, and they decide which chain is Ethereum. So you're automatically you're not competing on an even playing field in terms of brand. And then, do you know how hard it is to bootstrap an entire blockchain ecosystem and make it valuable and make it secure? You could tell even ETC, which had a lot of money, ETH Classic, which had a lot of money backing it, ultimately it ended up getting 51% attacked a bunch of times because it's very, very hard to make it successful. So that means that you actually do lose when you lose a debate about what should be in an upgrade. You are losing out on something. And if you are a minority power, the majority has used its powers adversely to you. And there are fair exercises of majority power and there are unfair. So, and certainly the stable coins affect things, right? Because a potentially powerful voice in deciding what should go into an Ethereum upgrade would be, for example, the Aave community, let's say, right? Because it's a very big protocol in Ethereum. But let's just say they disagree with something that the core devs have proposed and the validators are potentially okay with adding to the client as an upgrade, it somehow adversely affects Aave in particular, right? Well, if Circle as a USDC issuer gets involved, there's a lot of USDC in Aave, right? Let's just say there was some plausible chance that there could be a contentious fork that would be successful if Aave supported it. Well, if Circle then comes in and says, we're supporting the one the core devs want to go, that's going to be the canonical USDC, right? That then really limits the Aave community's ability to go with the old fork, right? Because their community with all this non-canonical, now worthless USDC in it is going to be a zombie protocol where everyone is wrecked, right? And so there's just like this, there becomes this huge pressure to go with that fork, right? So it's not that they control it, but they're an extremely potentially strong influence. Now, it doesn't happen much, right? There haven't really been these contentious things, but so we don't see it in action, and therefore we tend to say, they would never use their power. They would just be neutral. I don't know if they would be neutral. You know what I mean?
Well, it's not. I think it's not even. I wouldn't even go as far as saying like USDC using their power. I'd almost just say like they can just say that it's redeemable on this chain and it's not redeemable on this chain. It's not. They don't even have to. Yeah. I guess I almost think of it like it less like politically charged and more just like, no, this is where you can get your dollars, right, and this is where you can't get your dollars, and this is the decision we're making. And I mean, even with like the upgrade to the merge, USDC could have said this is redeemable on proof of work Ethereum. Of course, that there's like obvious agreement to go with proof of stake Ethereum, but yeah, I think that is that's a very like obvious sort of power that all like these RWAs have. And it'll be interesting to see if there's ever a scenario where this like really comes into fruition.
Well, I mean, some of the eigenlayer stuff touches on that, right? And the main takeaway, right, that I want people to get, because again, it's something that where a lot of like founders and actually like very knowledgeable people I respect, a lot of times argue with me or don't seem to think I'm wrong or whatever. But my takeaway from all the scenarios we just described is that forking is not a frictionless, perfect minority remedy.
Yeah.
It's just not.
Yeah. Well, that's a good place to end. Where can people find you on Twitter?
I am at LEX_NODE. That's at LexNode on Twitter. And I have the same username on Telegram. If people want to DM me, and I'm pretty much always around.
Awesome. Thank you so much.